May I have my lord's leave to mention one case. A second appeal has been fixed for 27. Lord, last time we have taken time to on 12th of this month to go through the LCR. We filed the application for inspection, but
आपको वहाँ पे तो क्या बोलेंगे आप? यहाँ पे आपके सब जूनियर लोग यही कोर्ट में रहते हैं. यहाँ स्लिप दीजिएगा आपको तुरंत मिलेगा. हाँ, LCR तो यहाँ रखा हुआ है और आप लोग के कहने पे यहाँ रखे रहते हैं.
तो मिलट एक चीज से प्रे करना है कि अगर हमारे ईमेल पर सॉफ्ट कॉपी मिल जाए.
नहीं दे सकते हैं सर, पिछली बार भी आपको मना कर दिया कि नहीं दे सकते. LCR का फोटो कॉपी आता है हम लोग के पास, हम लोग वो सब नहीं दे सकते.
LCR का फोटो कॉपी हम लोग ले सकते हैं?
नहीं ले सकते हैं. हम उसको कैसे हम आपको फॉरवर्ड कर दें? नहीं कर सकते.
तो यहीं पर देखिए,
यहाँ पे देख लीजिए. अभी तो आपके पास 2-2.5 घंटे तक टाइम है, आप देख सकते हैं. LCR के लिए आपको इंस्पेक्शन फाइल करने की कोई जरूरत नहीं है. आराम से यहाँ कोर्ट रूम में बैठिए, इतना बड़ा बड़ा टेबल है, वकील सब रहते नहीं है, अपने इत्मीनान से देखिए, कोई दिक्कत नहीं.
तो सबसे अच्छा
जो पढ़ने के लिए तैयार है उसको कोई प्रॉब्लम थोड़ी है. प्रॉब्लम उसको है जो पढ़ने के लिए तैयार नहीं है. चलिए,
I asked my office कि भाई मिला मतलब हम लोग को LCR नहीं.
काम ही नहीं है, रोज ही कोर्ट में बोलते हैं. यहाँ पे सब लोग अपना इंस्पेक्शन खुद ही करते हैं.
Paso case on supplementary list item 4, second appeal 360 of 2018.
Appellant is the plaintiff. We lost the case from both the courts. Now this suit is for declaration of the rights of the plaintiff in the land. Now the case of the plaintiff, Your Worship, they say that it is Ramu Murmu and Devi Murmu, they were the brothers.
Just
I'll just read out from the
Just- you can read it out from the appellate court judgment or trial court judgment.
any first from the trial court.
First from the
Trial.
trial court judgment. You have furnished type of courts.
Yes.
Yes. Yes, from the trial court.
The case of the paragraph 2, you know,
Yes.
the paragraph 1 is the prayer.
Yes.
The case of the plaintiff in brief is that the land under Khata number 17 of Mosha Kilabani within case so and so were recorded in the name of Kalyan Murmu. Kalyan Murmu, son of Ramu, Mugli Majayan, wife of Devu Murmu. So this Ramu and the Devu Murmu were the brothers, and Kalyan is the son of Ram Murmu and Mugli Majayan is the wife of Devu Murmu.
So it was a joint name of Kalyan Murmu and Mugli Murmu.
Yes.
Mugli
Mugli Majayan, because she is the wife of Devu.
Yes.
Each having equal areas, and they were in joint possession. Ram Mumu, Devu Mumu were brothers. But at the time of preparation of records of right in the year 1923-24, Devu Mumu was dead without any issue, and hence the name of his widow, namely Mugli Majain, was recorded along with Kalyan Maji in the records of right through Mugli Majain was recorded as co-tenant with Kalyan Maji. So that is the simple case. We have a case that this Devu Murmu was issueless. Since he was issueless, so his wife name was recorded as co-tenant along with the Kalyan Murmu, who was the son of the Ram.
Mr. Co-tenant तो कुछ यहाँ पे was recorded as co-tenant.
Co-tenant with Kalyan Murmu, but in fact Kalyan Manji was possessing the entire land because Your Lordship, as per the CNT Act, the lady, the daughter doesn't have the right, so this, she was the wife, she was recorded as a co-tenant. As described in schedule within district of so and so. So this is the plot and the area number is being mentioned.
So your case is that the entire property
After the death of the
devolved
Mugli,
on
after the death of Mugli Majai.
no after death of Mugli no
Yes, Mugli, because Mugli and Devu.
after death of Devu after death of Devu came to Kalyan.
Kalyan. But also in the records,
But Mugli was
the widow of the Devu.
Widow of Devu.
And
Therefore, her name was also mentioned.
and there is no issue out of that. We have that case.
Devu had no
Issue. Devu and Mugli.
yes.
So, Your Lordship, I'm just skipping at that area in the plot number. So it's now on the next page, Your Lordship. 7th line from the top. Now, sixth line, which are recorded under Khata number 326 in the Revisional Survey Records of Rights. Mugli Majain died sometimes in the year 1930. So, hence, all the interest, if any, of the Mugli Majain devolved upon Kalyan Maji, who continued to possess the entire land of Khata number 17, having no concern with any person.
Khata number 70
Yes, sir.
and Khata number 326 are one and the same.
Yeah, one and the same. No, Your Worship, they are the two khatas, khata number 17 and khata number 326. They are the two khatas. Khata 326 ka already it was there. The dispute is regarding the khata number 17. Kalyan Maji, while possessing the land of khata number 17 of Moja, Tilabani, kept one Chotu Maji of village Murgabani for helping him in agriculture. Thus, Chotu Maji was residing with Kalyan Maji and was working as servant for agriculture. So we have a case that this Chotu Maji was the staff of this Kalyan Maji. Chotu Maji was married to one Karila Maji. Therefore, both husband and wife were living at the house of the Kalyan Maji, and they are working as servant under the Kalyan Maji and were helping in agriculture work. This is the dispute, Your Worship. They say that this Karila is the daughter of the Mugli Maji, and we say that Chotu was our staff and he married to this Karila and they were the staff under us. And Karila, she's the daughter of the Mugli Maji. And they are working as house. The plaintiff Sarodi Mashain is the daughter of the Kalyan Manji. Actually, in fact, the Kalyan Manji had one son and one daughter, Your Worship. Son died, so the daughter remained there, Sarodi Mashain, and has been married with Pandu Manji of village Tilapani. And as Kalyan Manji has no male issue, Pandu Manji was also living at the house of Kalyan Manji, and he was also looking out the agriculture work of Kalyan Manji. Kalyan Manji died in 1940, leaving behind his only daughter Sarodi Mashain, the plaintiff who inherited all the interests of the Kalyan Manji and became the absolute owner of all the lands of Khata number 17. And she continued to possess the same peacefully with the help of her husband and the said Chotu Manji. Chotu Manji died, leaving behind the defendants number 1, 2, 3 on his sons, who continued to live in the house of the Sarodi Manai with their grandmother. This Chotu and the Karela, they have one son, Nanda, and Nanda had three sons. Those are the defendant number 1, 2, 3. With their grandmother, Karela Manjain. Karela Manjain died in the year 1992. Though Manjain had no interest in the land of Kalyan Manji or any land under Khata number 17, but as her husband was working as Munshi of Kalyan Manji, she managed to get her name entered in the recent revisional survey, which is not known to the plaintiff. Very recently, the plaintiff came to know that the said Karela Manjain claimed to be the daughter of the Devu Manjain and Mungli Manjain, and thus she wrongly get her name entered in the revisional survey records of right. Recently, plaintiff obtained the certified copy of the revisional survey records of right in the month of September 1996 and came to know that the name of Karela Manjain is recorded in new Khata number 326, and for the lands mentioned in schedule as the lands under Khata number 17 of Moja Taluvin have been recorded under the new Khata number 326. The said Karela Manjain is recently shown to be co-sharer of the Sarodi Manjain, but in fact, Karela Manjain has no interest in the land mentioned in the schedule. She, in connivance with the survey staff, got her name entered under Khata number 326 new of Moja Tilabani, under which all the lands mentioned in schedule are renumbered and are recorded. Karela Manjain and her husband were possessing the lands on behalf of the plaintiff as Munshi. They have no interest other than to receive duties of their own. But on the basis of this permissive possession, Karela Manjain, ancestors of defendant number 1, 2, 3, got her name entered in the records of right. The defendants have got no right, title, interest, or possession in any of the lands mentioned as per the schedule. The plaintiff and defendants are the members of the scheduled tribe, and therefore the Deputy Commissioner Dhanbad has been made party as a performer defendant, but no relief as claimed against the defendant number 4. The compliance of section 81 of the CPC is not required. Karela Manjain was not the daughter of the Devu Manjain. As Devu Manjain died issueless, cause of action for the present suit arose on 18/9/96 when the revisional survey of records was put, and 4/9/96 when the plaintiff came to know about these entities, and also on subsequent days with the jurisdiction of this court. For the purpose of jurisdiction and court fee, the suit is valued at ₹25,000. The plaintiff paid for the following reliefs: for a decree in favor of the plaintiff and against the defendants, for declaration of the realty rights of the plaintiff in the lands mentioned in the schedule, for a decree in favor of the plaintiff and against the defendants, for declaration that neither Karela Manjain nor defendant number 1, 2, 3 have got any interest in the land mentioned in the schedule, for a decree for cost of the suit, for a decree for any other further relief for which the plaintiff is entitled. Now the defendants appeared and filed their written statement on, amongst others, on the ground of its maintainability cause of action, had under the law of specific relief, barred by the law of limitation, undervalued, bad for non-joinder and misjoinder of parties. According to the defendants, the property under Khata number 17, Moja Tilavani, belonged to two brothers, Devu Manji and Ram Manji, and they exercised their act of possession along they were alike. Ram Munu is Ram Manji, while in possession of the property under Khata number 17 with his brother Devu Manji, died leaving behind a son Kalyan Manji, and they jointly possessed and possessing the entire land. While Devu Manji, the son was of Ram, thus in possession of the land with his wife Mangli Manjai, died, and the entire property remained under the joint possession and the ownership of the Kalyan and Mangli Manjai, each having half share. It has been submitted that the Mangli Manjai recorded year died sometimes in 1950.
No, I don't get this. You see, Ramu, this Devu died leaving behind Kalyan.
No, Your Lordship, there is some mistake. In fact, Ramu died leaving behind Kalyan Manji.
Just a moment.
That's
Ramu died leaving behind Kalyan Manji,
yes.
and the property.
Kalyan Manji is the son of the Ram Manji. He is a son. And Devu died issueless.
Just a moment. And while Devu
Died issueless. His wife Mangli.
that is not the
it's
defendant's case.
No, defendant case is ki Devu and the Mangli Manjai had one daughter,
Mangli Manjain is wife of
Devu.
So
Initially,
Kalyan
wife-
and Mangli Manjain each were having half share.
Yes, Mangli and Kalyan were having half share.
Okay.
So defendant case is this Karila is the daughter of Mangli Manjai, each having half share. It has been submitted that the Mangli Manjai recorded year died sometimes in 1950 and Kalyan Manji died sometimes in 1940. And on the death of his Kalyan Manji, his daughter Sarodi Manjai remained under the care and custody of the Karila Manjai, and the entire property was under the possession of Karila Manjai. She alone cultivated the land growing paddy thereon with her son Nanda Manji. Karila Manjai, wife of Chotu Manji, died leaving behind a son Nanda Manji, whereas Kalyan Manji died left a daughter Saradi Manjai, wife of Pandu Manji, and they acquired the property in question by rule of inheritance, each having half share over the entire suit property. The plaintiff, in order to cover her claim, falsely stated various false and incorrect statements and interlaid that Kalyan Manji kept one Chotu Manji for helping in agriculture work are wholly false. It is most unfortunate on the part of the plaintiff that while drafting of the claim, never remember about the family background of the parties for better appreciation. It is said that Devu Manji, Ramu Manji were full brothers, and these are admitted, and Shrimati Kerali Manjain, wife of Chotu Manji, who is daughter of Mungli Manjain and Devu Manji, as well as son-in-law of the Ram Manji. Therefore, instead of going deep more so far the relationship of the parties, it can safely be said that the husband of Shrimati Kerali Manjai, each of one Chotu Manji, as falsely stated in the plain, more so, son-in-law cannot be kept as servant for cultivation under Kalyan Manji. The grandmother and grandfather of the defendants, which Kerali Manjai and Chotu Manjai, all along exercised, and Chotu
What were the
Manji.
issues framed? Now you come to the issues.
Issues are on page 12 below.
Yes. Which is the issue which is relevant?
Issue number 5 and 6, Your Worship. Whether the title vested upon the
Five and issue
plaintiff, whether the plaintiff is entitled for the declaration of right title and interest over the suit property. This is the first is maintainable hai.
These are for just formal and
Yes.
ornamental.
5 and 6 are moved. Regarding our prayer, Your Worship. These issues are most important in this suit and interlinked with each other. Therefore, taken up together for the sake of convenient consideration. There, in the judge, shortly stated the case of the plaintiff is the land mentioned as per schedule of Khata number 17 of Moja Tilavani were recorded in the name of Kalyan Mumu, son of so and so.
These are again the case of the
Case of the
parties. You can just
The finding
case
of the court is
defendant also
that
mentioned.
I'm just skipping
Then,
up. It's on the
then
for the
it-
next time.
is
First,
the
second,
position.
third page, mein, Your Worship.
Yes.
Third page, mein, second paragraph. This one I'll just point out, Your Worship. In the upper portion, the fourth line in that, According to the defendants, because in the deposition they have come to this, according to the defendants in title suit number 309 of week 49.
I don't get it paid.
Your Lordship, this is the findings, Your Lordship. The first page we just skipped. That is the case of the plaintiff. Second page, is the case of the defendant. In that
Case
case
of the plaintiff and case of the defendant.
Then next page, Your Lordship.
Yes.
Next page. In the case of the defendant itself, Your Lordship, page fourth line from the top.
According to defendant.
According to in title suit number 309 of 49, the learned Munsif Dhanbad considers that the families of the parties in dispute are governed by Dayabhal School of Hindu law, and father of the plaintiff, Nandu Soren, is the reversionary heir to the estate of Devu Mamaji. According to the defendants, the parties to the suit and their predecessors in interest continued into the possession of the land as per their convenience, but there has no partition by maintenance bounds, and by the defendants got their half share over the Schedule A land. So this title suit 309 of 49 has not been pleaded in the WSC, Your Lordship, but subsequently during deposition they have come, and in that title suit this plaintiff was not the party, Your Lordship. Now, the court finding, Your Lordship.
No, the predecessor in interest of the plaintiff must be party.
The predecessor interest of the plaintiff.
This has been exhibited.
Yes, Your Lordship.
Need not be pleaded specifically.
That was
No, there is no necessity to have a pleading for that. Anyways, what is the finding? Let us
Yes.
have a look at it. Just
For-
come to the finding.
for
All
the
the
same.
evidences have been discussed.
Yes, Your Lordship. The in plaintiff 7 witnesses have been examined. Now plaintiff has not been examined because it has been deposed by PW3, the son of the plaintiff, that she is not able to walk and move. Your Lordship. That has come in the next page. Your Lordship.
Sorry. How does that make a difference?
Yes,
Because
it doesn't make it, but
substantial
I am just pointing.
This the certified copy of the judgment in title suit was exhibited as Exhibit C,
Yes, Your Lordship. it was.
and Khatyan was also exhibited,
Yes.
and then the certified copy of the decree was also exhibited. All
That
these
is
things were
title suit.
exhibited.
Yes.
Yes. So what is the finding?
Finding is, Your Lordship. It's on the
On perusal of pleadings?
DW2, Your Lordship, DW4, DW6.
No, everybody has been examined.
For the sake
That
of
happened.
convenience, Your Lordship, on perusal of pleading, आ जाएगा उससे पहले भी दे देते that. Otherwise,
On perusal of the pleadings.
on perusal of the pleadings, that is plaint of the plaintiff, it appears that there is a dispute of only one khata bearing khata number 17 of Tilabani, village Moja.
Correct or not?
It's correct.
Anything wherever you find incorrect, you just point.
Yes.
Continue.
There is no scope of any other khata in the plaint except khata number 17. But the PW3 Rupla Marali, the son of the plaintiff, has stated in para 1 of his examination in chief that the land is disputed at situated at Tilabani Moja in khata number 17, khata number 15, having area of 16 acres 8 decimals. In this way, plaintiff witnesses stated regarding khata number 15 of the suit land, which is beyond and the pleading of the plaintiff. On perusal of the plaintiff, it appears that there is a suit for declaration of title, etc. And the plaintiff has paid in relief portion for declaration of her hereditary rights in the land mentioned in the schedule of the claim. But the plaintiff has not produced the record of rights in the year 1923-24 of khata number 17 of Tilabani Mosha as per amendments of the para 1 and para 2 of the plaint or any other document showing her title over the suit land as per schedule in support of her case. Neither the plaintiff has examined herself nor she has produced and exhibited any title conferring the documents in support of her case at all.
The plaintiff was the descendant of?
Kalyan Mara.
Kalyan.
But the finding
So
of the court
that is not in dispute.
dispute. That is because they also admit.
They also admit that it was recorded. Then this is how basically genealogy is in dispute.
Yes, that is basically, and so that's why. So the finding
it
of the
is
court is that we did not
We
bring any
forget it.
document,
It is
but that is not in dispute. That again, in the light of relied upon the rulings of the defendants from perishable reports. But the defendants have examined in all 7 witnesses and exhibit A, B, B by 1, C, D, and E in support of their defense. Defendants exhibit A is the rent receipt of Khata number 17 in the name of Kalyan Murmu. Exhibit B is the sale deed executed by the minor Nandlal Manji. Now this Nandlal, they are relying on that कि Nandlal Manji has also sold the land. Nandlal Manji is the descendant of defendants. This is Mugli Manjari. Kareli ka beta, Kareli and Chotu's son. And he has executed the sale deed while he was minor. Executed by minors Nandlal Manji, son of late Chutu Manji, and Kerala Manji, wife of late Chutu Manji, in favor of Palu Manji in respect of Khata number 17, about which it has been argued by the defendants that the father of the defendants had acquired right, title, interest and possession from Kerala Manji and Chotu Manji, therefore transferred the land in the capacity of owner. Exhibit B by 1 is the sale deed number 2951 dated 2448 executed by Mangli jointly in favor of Mangal Manji lien in respect of Khata number 17, about which the defendants argue that the defendants' ancestors and the plaintiff ancestor have jointly owned and possessed the land under Khata number 176. Hence, the defendant is the great grandson of Mungi Majai, wife of Dipu Manji. Exhibit C is the judgment of title suit 309/49, and Exhibit E is the decree of the said title suit, which was filed by the minor Nanda Manji against Mongli Manjai, about which the defendant argued that it proves that the Chotu Manjai is the husband of the Kereri Manjai, and Kereri is the daughter of the Mungli Manjai, and Nanda Manji, son of Chotu Manji. And Exhibit D is the certified copy of the new Khatyan prepared by the Revisional Survey Authority in the name of Sarudi and Kereri Manjai, about which the defendant argued that it shows the ownership and possession of the parties concerned. In this way, it appears that the defendants have established their defense in the light of the aforesaid exhibit, and there is nothing in rebuttal of the same. Became the plaintiff has not established her right title, and interest is nothing in rebuttal of the same, because the plaintiff has not established her right title and interest over the suit property. Although it has been argued by the plaintiff that the provisions of Hindu Succession Act, as per the Section 2 of the Act, is not applicable in case of scheduled time. Therefore, even if Kerala Manjai is said to be the daughter of Devu, she cannot inherit the property. On the contrary, Kalyan died leaving behind his son, Bigu Murmu, and a daughter, Sarudi Manjai. So the interest of Kalyan was inherited by his son, Bigu, and after his death, the entire interest was inherited by Sarodi, the only near relative of Bigu. So defendant also argued that the son is not competent to give evidence, and parties to civil suit must be examined personally as provided under Section 120 of the Evidence Act. And civil court has no jurisdiction for correction, modification of the records of right, and it is barred under Section 258 of the same Act. Although there is no rule of law that the plaintiff must examine himself as a witness in order to
What
establish.
happened in the appellate court?
In the appellate court, Your Lordship, again the issues were framed. That is at page 24, Your Lordship, in a page 8 of the judgment.
The point for determination.
Point for determination. Whether there
Here
are
is point of
issue-
determination number 2.
issue number 1 and 2 are the important, Your Lordship. Whether the original Plaintiff appellant has proved her title position over the suit led by producing sufficient evidence in support of her contention. If so, whether she was entitled to be declared as owner of the suit land, whether Kareli Manjain was the daughter of Devu Mumu, and in this regard she was entitled to inherit the property which was left by her father, Devu. Since these 2 points of determination invites common
You see, there was an exhibit C,
yes,
which was titled suit number 309 of 1949.
Yes.
It was exhibited,
yes.
which showed that Mangli Manjain had a daughter named Kelly.
That title suit mean was there that the Mangli Manjain.
Yes.
Yes.
So defendants had produced document to show that Mangli Manjain had a daughter.
So we are on that
So
point
just-
only. So that title should be given on the parties. Now if they say that the Kareli Manjain, so we didn't get that opportunity to contest that this Kareli Manjain is not the daughter of this Mungli Manjain. So that was, if we have an opportunity to contest that.
Did you produce any evidence to show that Mangli Manjain died in 1930?
That death certificate has not been.
There is no question of issuance of death certificate. There could be oral evidences, documentary evidences also.
But our specific case was that Mangli Manjain died without any issue in the year 1930.
So what
We
evidence
have
have you
given-
produced? What evidence have you produced to that effect?
That on affidavit we have given the statement.
That is not sufficient, no.
Yes,
They
but
are
that-
producing a document,
Yes,
whatever be it worth. It's after all, it's a decree of the court.
yes.
It is not just a statement or made in written statement or otherwise. They have produced some document to show that Kareli Manjain was the daughter. And your case was Kareli Manjain and Chotu Manjain, they were living as a servant. So it is not that these people are totally unrelated person. They were, Chotu Manjain was living as, Manji was living as son and Kareli was his wife. So you say that they had nothing to do with the family.
We say that the Chotu was the staff of the Kalyan Manjain.
But that
And then this Chotu got married to this Kareli Manjain.
and there is a decree which showed that she was the daughter of.
So that we say that was the suit which is being filed amongst their family members.
There is nothing. No question of law arises. You have read the judgment full text. Almost.
No, that time, Your Lordship, I have discussed with the concerned advocate who said, so there is no point. The only point which we can only, if we can remand back, Your Lordship.
There is
There
no
is
question of any demand.
No,
The
but
second
I'm just
appeal-
playing. No, I'm just playing, Your Lordship. I'm just playing. I'm also admitting it's not the case where Your Lordship. I'm not admitting Your Lordship. But the thing is,
I just wanted to know if there is anything. That is why we have been adjourning this case for 2-3
No, Your
days.
Lordship, in this case, actually, what has happened, the first date, there was no typed copy of the judgment of the title suit.
No, earlier also there were repeated adjournments.
No, Your Lordship, that day, one day it was adjourned because of reference was there, we could not
No,
come.
on 19/1/23 by way of last chance, 16/7/24.
Yes.
Then upon payment of rupees 1,000.
That is
Then
there.
19/9/24 upon payment of rupees 1,000 again. Rather 2,000.
Then 2,000.
Then
4,000.
I don't know. There is a 4,000 also.
No,
So
that
you
is-
don't say that. But
No,
still, you see,
it's
the
there.
whole point is, madam,
No,
when a case is dismissed for default, it causes a lot of disrepute to the council. I don't want that.
No, Your Lordship, we don't-
Restoring, I could have dismissed the case, but there is no point to
No,
dismiss
Your Lordship,
it.
yesterday actually what happened, yesterday it was for the first time. Last time we came for argument. But since there was no
but
typed copy, so
you
it was
have
adjourned.
such a big office.
No, Your Lordship, actually yesterday what happened, actually my two of the juniors, they are close friend marriages there, so they are not there. So the other junior, and in all the courts, first case was there, and we were on legs, And all of a sudden, then I came to the court, and then it was ki, tomorrow.
No,
it will
whatever
be
it
this.
is, we have heard you.
So it's not that ki we just want
No,
to.
no,
It's not that.
I
And
know
today
that
also
you will
Worship,
never
in the
avoid.
morning I was here.
There is
Morning
no
I was
point.
here. But immediately the case
Madam,
was called.
Madam, these cases, each one, I am hearing you for half an hour,
Yes.
right? You will not say that, no, it should be heard in 5 minutes.
No, Your Lordship.
There is no
Even
point.
I am admitting, Your Lordship, as such, it's not a case.
These cases,
Yeah,
they
I'm
take
also
lot of
fairly
time.
admitting.
The counsel has to be patient. You
Yes.
have to keep somebody in the court. And 4:30 के बाद तो कोई एडवर्स ऑर्डर नहीं करते, ठीक है? लेकिन किसी ना किसी का रहना जरूरी.
Like till morning, Your Lordship, all the courts were having first case. All of a sudden, this thing has happened.
This
But
is
this
not an
is not that.
excuse.
But no, it was fair, and we thought it is possible. Immediately, I came. here.
Second appeal, I don't want to dismiss the case for default.
Yes, Your Lordship.
Because once it is dismissed for default, restoration is a huge
No, yesterday
business.
also we were prepared, Your Lordship. It's not the case.
SA number 360 of 2018, for the learned counsel appearing on behalf of the appellant. The counsel for the appellant has submitted that
The only 2 points were there for Your Lordship. They are relying on the documents which has not been pleaded by them in their written statement, Your Lordship. And second,
this appeal has been filed against judgment and decree against judgment dated 6/6/2018, decree signed on 12/6/2018, passed in title appeal number 28 of 2005, passed by learned district and sessions judge Roman 11, Civil Court, Dhanbad, dismissing the appeal. The trial court judgment is dated 20/12/2004, decree signed on 6/1/2005, was passed in title suit number 128 of 1996 by Sub-Judge Roman 7 Dhanbad, whereby the suit was dismissed. Accordingly, the plaintiff is the appellant before this court. The learned counsel for the appellant has submitted that though there are concurrent findings recorded by both the courts, but a substantial question of law arises for consideration in this case inasmuch as the learned court has relied upon Exhibit C, which was judgment passed in title suit number 309 of 1949, to hold that Mangli Manjain died leaving behind a daughter, namely Kerala Manjain, although there was no foundational pleading in the written statement of the defendant referring to the title suit number 309 of 1949. The learned counsel has submitted that the specific case of the plaintiff was that Kerala Manjain was wife of Chotu Manjain, who was working as servant under their master, namely Kalyan Manjain, and therefore there is no question of any right title interest with respect to the property involved in the case in favor of Kerala Manjain. And Kerala Manjain was not the daughter of Debu Murmu. Yes. No problem. After hearing the learned counsel for the appellant, this court finds that the suit was filed for a decree in favor of the plaintiff against the defendant seeking declaration of rayati right of the plaintiff in the sued property and for a declaration that neither Kareli Manjai nor defendant number 1 to 3 have got any interest in the scheduled property. It was the specific case of the plaintiff that the suit was filed by Sarodi Manjain, daughter of late Kalyan Manji. The suit was filed by Kalyan Manji, and upon his death, the appeal was filed by Srimati Sarodi Manjain, daughter of Kalyan Manji. The Deputy Collector Dhanbad was made pro forma party in the case. Sarodi Manjain had also died, who was substituted in the memo of appeal, who were the appellants, who ultimately pursued the appeal before the first appellate court. During the pendency of the appeal, the respondent number 3 had also died and was substituted by respondent number 3 to 3C. As per the case of the plaintiff, one Kalyan Murmu, son of Ram Murmu, and Mugli Manjain, wife of Devi Murmu, jointly owned and possessed the property in Khata number 17. It consisted of several plots. And Ramu Murmu and Devu Murmu were full brothers. And the property was recorded in their name. But at the time of preparation of record of right, way back in 1923-24, Devu Murmu had expired without any issue, and his share vested in his wife Mugli Manjain, and her name was recorded jointly with Kalyan Manji. It was the further case of the plaintiff that Kalyan Manji had kept one person, namely Chotu Manji, for helping in agricultural work, who married Kareli Manjain, and both stayed in the house of Kalyan Manji as servants. It was the further case of the plaintiff that Sarodi Manjain, who was the plaintiff, was the sole daughter of Kalyan Manji and inherited the entire property in Khata number 17, as Kalyan Manji died in the year 1940. It was a case of the plaintiff that Kareli Manjain wrongly claimed herself to be the daughter of Devu Manji and Mugli Manjain, and on that basis got her name entered in the revision survey record. And as soon as the plaintiff came to know about it, steps were taken and the suit was filed. The defendants, the case of the defendant number 1 to 3 was that they admitted that the suit property belonged to two brothers Devu Manji and Ramu Manji, and upon death of Devu Manji, he left behind his wife Mangli Manjain and Ram Manji died leaving behind his son Kalyan Manji. It was also admitted that after death of Devu Manji and Ram Manji, Mangli Manjain, wife of Devu, and Kalyan, son of Ramu, came in possession of the disputed land, and upon death of Mugli Manjain, Mugli Manjain died in 1950 and Kalyan Manji died in 1940, leaving behind only daughter Sarodi Manjain. The specific case of the defendant was that Kareli Manjain was the daughter of Mugli Manjain. And therefore, the plea of the plaintiff that Mugli Manjain had no issue and the property devolved upon Kalyan Manjain, upon Kalyan Murmu, who was the son of Ramu Murmu, was disputed. This court finds that the learned trial court framed the following issues for consideration, para 7. The learned trial court considered the materials on record and ultimately recorded. That in Exhibit C, which was judgment in title suit number 309 of 1949, and Exhibit E, the decree of the same title suit, Kareli Manjain was shown to be the daughter of Mugli Manjain. And also referred to Exhibit D, the certified copy of New Khatian, prepared by Judicial Survey Authority in the name of Sarodi and Kareli Manjain. The learned trial court, after considering the materials on record, held that Kareli Manjain was the daughter of Mugli Manjain And the property stood recorded jointly in the name of Sarodi and Kareli Manjhain. The learned trial court also recorded that the plaintiff did not produce any evidence to rebut these aspects of the matter, nor could establish these aspects of the matter. The learned court ultimately recorded that the referred to Section 258 of Chotanagpur Tenancy Act and observed that the court had no jurisdiction to correct or modify the record of rights. And the plaintiff was required to be examined as witness in order to establish his case. Because persons personally knowing the facts and circumstances must give evidence on his own behalf so that he may be subjected to cross-examination. The learned trial court ultimately held that the suit was barred by limitation, and also the suit was barred under the Chotanagpur Tenancy Act and dismissed the suit. The learned appellate court also considered the materials on record and recorded that it was an admitted fact that Ramu Manji and Devu Manji are real brothers. It is also an admitted fact that Ramu Manji died leaving behind only son Kalyan Munu and Devu Manji died leaving behind his wife Mangli Manjhain, and framed the point for determination as under. Running page 25 में मिलेगा, internal page 9 of the appellate court judgment. The learned appellate court also recorded that the original plaintiff, who had now deceased, raised a plea that Mangli Manjhain died without issue in the year 1930, and a share which was obtained through her husband devolved in Kalyan Munu, who was son of Ramu Munu and nephew of Devu Munu, who was the husband of Mangli Manjhain. The learned court considered the materials on record, including the Exhibit C, which was a certified copy of the judgment passed in title suit number 309 of 1949, from which it appeared that Mangli Manjhain died leaving behind a daughter named Kareli Manjhain. The learned court also considered the learned court ultimately recorded the finding that the learned trial court rightly held that Kerala Manjhain was Rayat of the disputed land with respect to half share. The finding is recorded as under. यहाँ से page number 28 से. While deciding the point of determination number 3, the learned court recorded that the plaintiff failed to prove the fact that Chotu Manjhain was only kept by Kalyan Manji as a caretaker and was helping in his agricultural work. The learned court held that Kerala Manjhain had acquired right title and interest over the property with respect to her father's share in the disputed land. and the learned trial court rightly held that Rayat of Kerala Manjain, Rayati right of Kerala Manjain with respect to her father's share, and dismissed the appeal. Finding with regard to point number 3 is as under. This court finds that the learned courts have scrutinized the materials on record and have given concurrent findings that Kerala Manjain was the son of Mugli Manjain. The judgment and decree of title suit number 309 of 1949 was produced in support of such a plea. This court is of the considered view that the same was rightly taken into consideration and other materials on record were also taken into consideration by the learned courts while returning the aforesaid finding. There is no scope for this court to disturb the finding of facts as recorded by both the learned courts when the same were decided after due scrutiny of the materials. This court is of the view that no substantial question of law arises for consideration in this case. Accordingly, this appeal is dismissed.
From date is for final resolve case item 2, first appeal 3 of 2023.
You are the plaintiff,
Allegedly, I was the defendant.
you were the defendant.
Yes.
The suit was decreed.
Suit was decreed.
This is first appeal number.
First appeal
Number?
of 2023.
Number
First appeal number 3 of 2023.
3 of 20.
Yes.
Defendant is the applicant.
Yes.
What was the suit for? Money suit. Money suit.
Actually, it was suit for. Basically, it was filed under the partnership application.
Okay.
Later on,
What was the relief?
the relief that they claimed for money of amount 29 lakh rupees, not from the original defendant, because the defendant was deceased prior to the filing of this suit. So they are claiming the amount from the legal heirs, that is daughter and wife. Wife is the defendant number 1, and daughter is defendant number 2.
Daughter and
Wife.
wife of deceased.
Yes.
Okay. Who was the deceased? What was his name?
His name was Surendra Kumar Yadav.
Samir Kumar.
Samir Kumar.
Samir Kumar Yadav, and they were claiming under okay, Samir Kumar Yadav, who was a
Yes.
partner in the partnership fund.
Partnership. However, that they claim that the firm was registered. That was of course registered under the Registration Act 1908, but not in the terms of Section 59 of the Registration Act the partnership
Form
act.
was registered. Registered means registered under which provision?
Under registration act only,
Under
but not in the
registration-
terms of section 59 of the partnership act.
Registration Act, Partnership Act, but not in terms of section 59
Yes.
of Partnership Act. What is the difference between the two? What is the difference?
The difference is that to claim under under section 59, liability if any liability occurs with regard to any third person or vis-a-vis the members of the partnership, then it must be registered under section in terms of section 59 of the partnership act.
What is the difference between the two? The registration will take place where? In the registry office only.
No, that will be.
That will be registered where? Like in Companies Act, you have registrar of companies, where the
Yes.
charge is to be registered. What about partnership?
May I read section 59 of the partnership act?
It is,
You are there in this case?
yes, under Partnership Act, it is registered before Registrar of Firms, whereas under Registration Act, it is registered before the District Sub-Registrar.
That's right.
So that is the difference.
So there is a forum
So
where
here
it
the-
has to be registered.
Here the firm itself is registered and there
How
the
many
deed is-
partners were there?
3 only.
Who will argue? Are you going to argue?
Yes.
You are there in this case, no? तो आप उनको क्यों छोड़ दिए? ऐसा नहीं करेंगे। फिर क्या होता है क्वेश्चन उनसे पूछेंगे आंसर आप करेंगे तो
नहीं
अच्छा
हम
नहीं।
I'll start.
You start.
Yes.
क्योंकि वो एक फ्लो है, एक
हाँ।
फर्स्ट अपील बहस करने का एक फ्लो होता है,
Absolutely.
एक सीक्वेंस है उसका। बताइए।
No, I'm the original defendant.
Sorry, yeah, please don't take it otherwise.
No, because your lordship had asked me that I don't promote my juniors, therefore I asked him to start.
देखिए आप लोग नहीं
So,
रहते हैं तो
this-
हम इनसे पूछते रहते हैं।
This at least.
लेकिन it's a
now-
very serious case.
Yes, absolutely.
Huge stakes are there.
Absolutely.
बहुत टेक्निकल है केस
And
आपका।
I'll show how unfair it is upon a person's widow and daughter whose husband dies, and immediately after his death, how the plaintiff and other person they managed and how this particular decree has been. Ultimately, strangely, your lordship would find that the decree is for 29 lakh, execution, her entire house is taken over. I'll show all those facts subsequently. Now here, I am the original defendant. Admittedly, there was a partnership deed between the persons who were partners. The partners were Samir Kumar Yadav,
Yeah.
and the two plaintiffs. The plaintiffs are Ramashankar Rai and Dinanath Roy. So, impact of that partnership and the disputes arising between partners, that would be absolutely relevant, and that is the key point of the entire case itself. So, before I read the statement made in the claim, I'll only pray that your lordship may see the partnership deed and then the facts which have been
Exhibit number?
stated. Yes.
There was also an arbitration clause.
Yes. In the partnership deed, there is an arbitration.
How the court has dealt with it?
Court has, because your lordship, section 8 of Arbitration and Conciliation Act, your lordship would find that probably this defense was never taken, and
No, in the
therefore
written
the court
statement it was
proceeded,
taken.
and
In the written statement it was taken.
It
That
was
issue was
taken.
framed.
but
You
this.
see, it is one thing to say that in a case where a case is filed, a party is filing a petition, that it should be referred to arbitration under section 8.
Yes.
But the party can simply raise an objection and not ask for a reference. It is permissible in
Yes,
law.
yes, I do get your lordship's point. Once that particular clause was there,
Yeah.
in the written statement, then in terms of section 8 of the Arbitration and Conciliation Act, it has to be at the time of, along with the written statement, this defense has to be taken that there contains an arbitration clause and the
And it was, you see, there are two things which can happen. One is saying that the suit is not maintainable because of arbitration clause. Other is that the dispute should be referred for arbitration. Right?
Yes.
There are two different things altogether. And for that, a separate petition under section 8 is required to be filed. But in order to raise a preliminary objection that it is not maintainable, it is not necessary to make a prayer that it should be referred to arbitration. Because there may be other objections to arbitration also.
yes.
Suppose a party comes and says that it should be referred to arbitration, it means that he is accepting that this is now an arbitrable dispute. There are so many nuances with the invocation of arbitration. Therefore, if a person simply says that it is not maintainable on the face of the arbitration clause, can it be referred, or what is how the court has to deal with it? This is a threshold. This is at the threshold. Now the case has been decided on merits. We have no option. We have to decide everything.
Yes.
But this is at the threshold. It has to be seen.
Threshold, it is there.
And now there is a recent judgment. Even if it is an unregistered partner, the arbitrator will decide.
Yes, that is there.
That very recent judgment.
That law I cannot dispute that once there is an arbitration clause, even in cases of unregistered partnership firm, the matter would be referred for arbitration.
Yes.
That is there.
You are
Here
defending-
I'll go into that law point also. Here I'll just show I'm not in any way escaping from the ultimate judgment passed by the trial court. I'll show how unfair it is. Your Lordship, you only see the partnership deed itself. Now, it is only 3-4 pages. Now, how the plaintiff now makes out a case once the business amongst them fails, how he makes out a case. Here, this is exhibit.
Deed of partnership.
Yes. This is dated 29/11/2002.
Was it
And-
heard by somebody at any point of time?
By your Lordship.
No. By anybody else?
No. No, this has not been heard.
Okay.
This was probably at the time of admission of first appeal. It might.
What marking है इसमें? और
उस-
मेरा मार्किंग नहीं आपको समझ आ रहा है
नहीं
एडमिशन के समय तो नहीं होगा
नहीं हो सकता है कोई
Coming for the first time for hearing.
आपको देख के ऐसा लग रहा है पहली बार आ रहा है इससे देख के ऐसा नहीं लग रहा है ना
हाँ नहीं
कभी तो हो सकता है कभी कुछ पढ़ा होगा
करके भेजे होंगे मैंने।
कौन मार्क करके भेजा
नहीं
शायद मार्क कर-
कोई मार्क
नहीं
करके
नहीं वो
नहीं
स्कैन
दिस इज नॉट परमिसिबल वहाँ से वो लोग मार्क करके यहाँ भेजते कोई बात नहीं यार इससे कोई फर्क ही नहीं पड़ता अच्छा है मतलब आई जस्ट वांट
नहीं
टू
नहीं
नो इफ somebody has heard
I think my learned friend would also agree that it does
Coming for
not.
the
It has
first
not
time.
been heard earlier.
कोई बात नहीं आज बस इसका कितना देर में खत्म होगा देखते हैं चलिए
The parties are Samir Kumar Yadav, and this is dated 29th day of November 2012. Then the parties are Samir Kumar Yadav, Dinanath Roy, and Ramashankar Rai. These three persons are there. Whereas I'm reading, it is only 3 pages, so I may be allowed to read them. Whereas the first partner already running land development business in Bokaro district, one of the project at Moja Bhawanipur at the rate Solangi D is on the way, and the first partner has invested nearly 25 lakh on the project. But due to further investment, first partner decided to take help of second and third partner on the project, and therefore this deed made under the following terms and conditions. That the office market of so and so would be so and so, all the documents shall be kept at the office, and then the fourth clause that the capital investment shall be contributed by the partner as below. First partner already invested on the project. He is the Samir Kumar Yadav who ultimately died, and the defendant, both defendants, number 1 and 2, are wife, widow and daughter of the Samir Kumar Yadav. Second partner is obviously second and third partner. They would be investing 7.50 lakh, and the profit and loss of the said project will be distributed between the partners as follows: first partner 50%, second partner 25%, third partner 25%. That the bank account shall be opened for this particular project in any bank at the Bokaro Steel City and operated jointly by Samir Kumar Yadav and Ramashankar Roy. So any bank account that was to be not operated solely by Samir Kumar Yadav, it was to be operated by both. That if any dispute arise between all the partners, it would be a parents wrongly type. Partners, the same shall be decided by the arbitrator, and the arbitrator shall be appointed by the mutual consent of the partners, and the decision of the arbitrator shall prevail. That if any partner have not satisfied to the decision of the same shall be decided in court, and so and so, so and so. So all the parties signed. This is dated 29/12/2012. Now signing and the document is not in dispute. The document was registered before district sub-registrar, that is not in dispute. And it was also not registered before the registrar of firms in terms of section 59 of Partnership Act. This is also not in dispute. So what would be the consequence? Ultimately, if there is a dispute inter se between the partners or their descendants also. So this is one would be question that would arise. Now your Lordship may see the claim, or it has also been quoted by the trial court in the judgment. Whatever your
We
Lordship
can see
directs
it from the trial court judge.
from
Almost quoted.
almost.
Is that correct?
No.
Fine.
That the plaintiff have brought this suit for recovery of 29 lakh only as principal interest at the rate of 18% per annum till realization jointly and severally from the defendant. Now here, your Lordship may kindly take note of the cost item. From the defendant, that they have said defendants, but actual relief is only against defendant number 1 and 2. And defendant number 3 is a pro forma. What is his role? That would subsequently transpire. The case of the plaintiff, as stated in the claim, are as follows. Samir Kumar Yadav, since deceased, husband of defendant number 1 and father of defendant number 2, executed a deed of partnership with plaintiffs on 29/11/2012, and the said deed of partnership was registered before the sub-registrar Charles Bokaro, while registered deed of partnership dated so and so, 29/11/2012. It is stated that prior to execution of the partnership deed, Samir Kumar Yadav induced the plaintiff to enter into a partnership for the land development business for one of the projects at Mauja Bhawanipur at the rate Solangidi. Samir Kumar Yadav told the plaintiff that he had already invested ₹25 lakh in this project, and for further investment, Samir Kumar Yadav told the plaintiff that they would be added as partners in this project, and by doing this project, the plaintiff would get immense profit. Believing upon the words of Samir Kumar Yadav, the plaintiff paid, here, your Lordship, I'll only put emphasis on few of the statements. The plaintiff paid ₹29 lakh to Samir Kumar Yadav on different dates for land development business. I'll show absolutely.
This is not a loan.
No, he just
He is
says.
projecting it as if it is a loan.
Yes, but that amount also, what he is saying, 29 lakh was paid by him to Samir Kumar Yadav. I'll show from subsequent statement, no such amount paid. Only amount that was paid was 5 lakh. That is all.
Okay, let's see.
I'll read it further. Now what he is doing, now the plaintiffs are doing, that defendant number 3 had paid 13 lakh to Samir Kumar Yadav. That also plaintiff is claiming on behalf of defendant number 3. Absolutely strange. I'll show that also. It is stated that Samir Kumar Yadav showed about 40 acres of vast tract of land pertaining to Moja so and so, all other plots of so and so, Bhawanipur, Solangiri. Samir Kumar Yadav projected very rosy picture regarding land development business, and upon his insistence, the plaintiff paid rupees 29 lakh only to Samir Kumar Yadav. Again, he says he is paying 29 lakh. Initially, the plaintiff paid rupees 5 lakh to Samir Kumar Yadav, and thereafter the plaintiff had, from here again, this is the portion which I am putting emphasis. The plaintiff had financial crunch, and therefore they approached, that means the plaintiff approached pro forma defendant Sri Ram Das Singh to provide monetary help to them for the development of the business. That means the plaintiff say that we, since we had financial crunch, therefore we approached, not Samir Kumar Yadav. We approached Ram Das Singh, who is the pro forma defendant number 3, to provide monetary help to them for the development of the business, and the pro forma defendant had agreed to pay an amount to the plaintiff. Again to the plaintiff, nowhere Samir Kumar Yadav's name is there. So that the plaintiff may give this amount to Samir Kumar Yadav for running of the business.
There is no privity between
Absolutely no
Samir
privacy.
Kumar
Absolutely, absolutely nothing. And how this ultimately all these
one
things
can
are
borrow money, beg, borrow, steal,
now.
and invest in business.
I'll
This is
keep
something like
further,
this.
I'll
Are you
keep
getting
further.
it? Yes. Yes. Take care of the observation. Right? I'm absolutely loud and clear. It appears this is what they want to argue at best. I can
I'll
anticipate.
show further from the document also. And this has been decreed, therefore I am so aggrieved.
Continue.
So therefore you would find from this statement at least that it is the plaintiff who approached defendant number 3 for payment to them, so that they could have paid it to the defendant number husband and Samir Kumar Yadav. So it is not Samir Kumar Yadav who approached them. Again, the pro forma defendant Sri R.D. Singh had given a check of having an amount dated so and so 2013, having an amount of rupees 3 lakh only in the name of Samir Kumar Yadav to the plaintiff. That means the check is in the name of Samir Kumar Yadav, but it is being paid to the plaintiff, and then so that the amount may be withdrawn by Samir Kumar Yadav for development of partnership business, and the said amount of rupees 3 lakh only has been shown in the accounts of the plaintiff in the partnership business. It is further stated that the pro forma defendant has also given, now pro forma defendant is giving check, has given check of dated so and so for Allahabad Bank having an amount of rupees 5 lakh, again so and so check of rupees 2,50,000 so and so, all given by pro forma defendant. All these checks have been given by pro forma defendant, and then last amount is 2,50,000 in the name of Samir Kumar Yadav to the plaintiff, and in this manner total amount of rupees 13 lakh was taken by the plaintiff from pro forma defendant, and they had given the said amount to Samir Kumar Yadav for development of business. It is submitted that the pro forma defendant had, after making payment of rupees 8 lakh, demanded proof of his payment to the plaintiff. Thereafter, plaintiff executed a money receipt. Now, again, plaintiff is executing money receipt. Plaintiff is accepting the check. Plaintiff is executing money receipt. Thereafter, the plaintiff executed a money receipt showing that the said amount was being paid in the partnership business of the plaintiff, and in the said money receipt, Samir Kumar Yadav was one of the witnesses. He is not even signing as a person acknowledging that I am taking the payment. He is only signing as a witness. In the said money receipt, Samir Kumar Yadav was one of the witnesses. After the execution of some money receipt, rupees 5 lakh was also paid to the plaintiff by pro forma defendant for investment in the partnership business, and all the investment of rupees 13 lakh only Sri Ram Das Singh was shown as invested by plaintiff in the partnership business, it is stated by the plaintiff made payment to Samir Kumar Yadav in the following manner by way of check and cash, with details of which is as follows, and this is the detail. Now what this includes, 29 lakh, the payment made by the pro forma
Except
defendant
rupees
number
5
3.
lakh. Except rupees 5
Yes,
lakh.
yes. Play-
This is cash.
Yes, only the payment made by pro forma defendant to the plaintiff, and for which the plaintiff are executing acknowledgement to the pro forma defendant, that amount is also included in this to make out a total sum of rupees 29 lakh, for which the pro forma defendant never filed a suit. He does not come forward as a plaintiff to claim his share of money. Plaintiff claim on the basis of defendant number 3. Now I'll read it further. Samir Kumar Yadav had also executed 3 money receipts for amount for which he had taken from the plaintiff on different dates. After making such a huge investment of rupees 29 lakh, the plaintiff started to inquire from the Samir Kumar Yadav regarding the status of financial condition of the business, and he, on some pretext or the other, did not give the actual status of the financial position of the partnership business, and later on, upon inquiry made by the plaintiff, they found that no land for land development business was ever purchased by Samir Kumar Yadav, and in order to deceive the amount of the plaintiff, Samir Kumar Yadav executed a deed of partnership business though actually no partnership business was started, and nothing was invested by Samir Kumar Yadav in the business, and he had taken 29 lakh by the plaintiff by playing fraud upon them. Here I'll pause here, because this is major amount portion where now whole statement why this was actually diverted, because if the plaintiff would have directly filed a suit claiming that they were partners of a partnership firm and that the partnership business had failed, and therefore they could not have filed a suit straight away. So therefore the allegations of fraud were necessary. But allegations of fraud are absolutely omnibus in nature. No specific instances of allegations are there. He only said that it was absolutely fraudulent. But from the previous statement, mainly the plaintiff also.
His cases that there was no land development.
Yes, yes. But let us assume what is the statement. This entire thing has to be seen together. Now their own statement is that they approached defendant number 3. Defendant number 3 paid money to them, that is the plaintiff.
That's right.
And the amount was entirely invested in the partnership business. So these 3, that means Samir Kumar Yadav and the 2 other plaintiffs, they all 3 were joined as the individually were partners in a partnership. So if the 3 partners they enter into a venture and the partnership firm ultimately fails,
liability, asset, everything is joint and several.
then yes,
to the
absolutely
extent
all
of the
3 would be
shareholding.
liable. Why to fasten a duty entirely upon one partner, particularly the moment he dies, the entire suit was filed, and
Suit was not filed for dissolution.
no suit whatsoever. No suit for dissolution.
It is just for recovery of money.
For recovery of money,
As long as 3 partners are intact, the liability remains joint and several.
joint, etc.
The question of division of liability, asset, etc. comes only when there is a suit for dissolution of partnership.
Yes, exactly. So no suit was filed, and no suit. So therefore, there was no accounting of partnership business, no assets of what was the asset of partnership business. No accounting was there, and your lordship would also be aware.
What are these 3 checks issued? Who issued these checks?
Pardon?
These checks were issued by Samir Kumar Yadav. In whose name? There is a chart just below this.
Yes. These were checks issued by Samir Kumar Yadav. Absolutely
To
no. To they say that it was issued to the plaintiff themselves. To the plaintiff.
To the plaintiff.
To the plaintiff. But
Are you sure? These checks
It
have
is,
been
it is
exhibited.
already exhibited.
Exhibit 331 and 321.
Yes, it is in the name of Ramashankar Rai.
So this amount is being returned by Samir Kumar Yadav in the name of defendant number
3.
3. Defendant number 3 is Ramashankar Rai, no?
No, he is the plaintiff.
He is
He is
plaintiff number
plaintiff.
1. So these checks were
Plaintiff
issued.
defendant number 3 is Ram Das Singh.
Okay. So these 3 checks were issued in the name of this.
In the name of plaintiff number 1.
It was honored, dishonored.
He says that the Samir Kumar Yadav, I may be allowed to read the further
Okay, please
statement.
carry on.
It is stated that when the plaintiff got information that Samir Kumar Yadav had no information, had no land in Moja, Bhawanipur, so and so, the plaintiff started making demand of their refund of their amount, which was taken by Samir Kumar Yadav. Samir Kumar Yadav, in order to make part payment of the amount, had issued 3 post-dated checks of IndusInd Bank. Details of the check are as follows. After some days, the issuance of post-dated check, Samir Kumar Yadav told the plaintiff that he was suffering from some disease and he advised the plaintiff not to deposit the aforesaid check for encashment. Believing upon the words of Samir Kumar Yadav, the plaintiff number 1 did not deposit the aforesaid checks in his account, and in the meantime, Samir Kumar Yadav sold left for heavily award on 14/5/2014. After the death of Samir Kumar Yadav, defendant number 1 and 2 have inherited all the properties of Samir Kumar Yadav and they are enjoying the same. It is further submitted that Samir Kumar Yadav has constructed a multi-story building at Chira's Chas and the defendants have inherited the same and are in possession of the same, are enjoying the property also. It is stated that the plaintiff number 1 got a legal notice issued on 14/10/2014 to the defendant number 1 for making payment of rupees 29 lakh within 15 days from the date of receipt of the legal notice, making of the payment, and instead of making payment of rupees 29 lakh, the defendant number 1 got the legal notice replied through her legal lawyer so and so on flimsy ground that on the plaintiff have brought the suit for recovery of 29 lakh for so and so. So then the defendant number 1 and 2, they filed a written statement, and the main portions of the written statement I may be only allowed to read, but Your Lordship, here we essentially, what we have denied is, the statements are that we are in para 3 of, at page 5, Your Lordship would find that we say that we are not privy to any contract between the parties, and therefore we are not liable to make any payment. And what had transpired between the 3 partners was between the 3 partners, and rest all statements were denied. Now only difficulty what is there is that the defendant number 1 and 2, they did not even contest the suit after filing the suit, and they did not come to the witness box. That is the whole difficulty.
Defendant number?
1 and 2. That means the contesting defendant, respondent number, that means appellant here.
Did not contest the suit.
No, not
But
contested.
only
that
filed
means
the written statement.
written statement, but they did not appear in the witness box and they did not produce any evidence. So I'll just.
What about defendant number 3?
He supported the case of the plaintiff, and his written statement has been mentioned in running internal page 9 of the trial court judgment, paragraph 4. He supported the entire case of the
The partnership deed is a very small deed.
yes.
There are terms of partnership deed which are to be read as per the Partnership Act. Isn't it? There are certain terms which are to be read as per the Partnership Act. नहीं, ऐसा कुछ नहीं है.
They have to be read. So
They have to be read into it because there is no negative governing to that effect. There are certain terms which are to be read. into it. कुछ तो था भूल गया.
Here,
Partnership.
before I'll rely on that, there is, as your Lordship pointed out, that no suit for dissolution of partnership firm was ever instituted first. Second, the suit was clearly barred in terms of section 69 of the Partnership Act, which very clearly says, and this ground was taken in the written statement by the defendant number 1 and 2, and even assuming that this ground was not taken, then also the court has to see that the suit itself is not maintainable in terms of section 69 of the Partnership Act. Section 69 very clearly says that if a partnership firm which is required to be registered in terms of section 59 of the Partnership Act is not registered, then the consequences of non-registration has been given in section 69.
What is the consequence?
And the consequences are, your Lordship may see section 69. First, your Lordship may allow me to place section 59, which says that the partnership firm shall be registered, and then section 59 says, when the registrar is satisfied that the provisions of section 58 have been duly complied with, he shall record an entry of the statement in a register called Register of Firms, and shall file the statement so and so. So therefore, section 59 mandates that the registrar of firms shall maintain a register of firms where the entry shall be made with regard to the partnership firm and the partners who are there. That means a synopsis of the entire partnership firm that would be registered in terms of section 59. And then 69 says, effect of non-registration. No suit to enforce a right arising from a contract or conferred by this Act shall be instituted in any court by or on behalf of any person suing as a partner in a firm against the firm. This suit was not against the firm, but I'm covered by the second one. Against the firm or any person alleged to be or to have been a partner in the firm, unless the firm is registered and the person suing is or has been shown in the register of firms as a partner in the firm. So the plaintiffs, here the two plaintiffs, they were never shown as partners in the register of firms maintained by the partner registrar of firms. So therefore, absolute bar in terms of section 69.
You see, they have neither filed a case as representing or a partner of a partnership firm. That is not the cause title by itself. They have filed their case in their individual.
Absolutely.
And the
yes.
partnership firm is not.
So
Their entire case is that they had paid certain money and ultimately it was to be refunded. And since Samir Kumar has expired, they are seeking refund of it.
yes, I do get your logic.
So therefore, bar under section 69, how would it come?
Yes, I'll show why. Now, can a person, now admittedly the two plaintiffs and Samir Kumar Yadav, they had entered into a partnership business, and this clearly reflects that who was to do what, who was to invest and who had already invested. All those were recorded in a partnership, the document. That document is not in dispute. The effect of the document is in dispute. So if the document itself had recorded that this was the thing that was required to be done, then can two persons escape their liability and shift their liability on a person, on a third partner, saying that no, had it been an absolutely different case, if they would have shown that now.
Let us put it differently.
Yes.
In a case where two persons say that they have invested money in a partnership firm can they seek recovery of any money which has been invested in a partnership firm without instituting any case against the partnership firm?
No. No. Because
And in a case where that
Absolutely.
particular firm is unregistered, what is the consequence? The consequence is that all the partners have joint and several liability.
absolutely.
Is that the consequence?
Yes. Absolutely.
In
Because
case,
how can a single partner, because profit and loss, I'll be liable in terms of profit and loss which is there in the partnership deed. The partnership deed at best would have said that I was liable to 50% of profit also and 50% of loss also. But in again the terms of the
by
partnership,
taking a plea that there was no property, there was no business, Samir Kumar Lal had disclosed that he had invested huge amount and he had no money for further investment. So if a person says that there has been fraud, then the day he discovered the fraud is to be disclosed. And whether by basic due diligence this fraud was evident. If there was no, it is not a thing that they wanted to start a new business. Rather, it's a thing where the business was already there and they had to invest certain money in that business. So their plea that it was non-existent, basically this plea of fraud has been put in only to overcome the
absolutely
arbitration
this is
clause.
my argument, because the partnership deed has been executed in the December 2012. Samir Kumar Yadav dies after 1.5 years from that date in 2014, mid 2014, and during this, the plaintiff himself makes a statement very clearly, and this has come in evidence also, that after some days, when they discovered that there was no such land, when they confronted this to Samir Kumar Yadav, then Samir Kumar Yadav said that I'll return your money. No case whatsoever was instituted by them when Samir Kumar Yadav was alive. No police complaint, no legal notice, nothing, absolutely nothing.
And this check which was issued by Samir Kumar Yadav, let us have a look at that check. This check has been issued in his individual capacity,
Yes.
not as a partner of the firm.
Even if he would have been issued as partner of the firm, then the partnership business itself would have been liable. The entire business. Now he cannot file a suit. He says that his suit, my learned friend pointed out one evidence where during his evidence he says that मैंने यह partnership deed के तहत यह मुकदमा लाया. That is what he said. He is not bringing it in his individual capacity. That means he is bringing the suit as a partner of
I've
the.
heard you. Let me hear him for 5 minutes.
Yes.
Because this matter is not going to be over today. We have lot of orders cases to be taken up. We will
Absolutely.
hear it on some other day. But let me just find out as to what he has to address so far as these points are concerned.
Yes.
What do you have
so
to say?
May I
You just
only request one thing. Any other day but 2:15.
okay. We'll do that. अब बताइए आपको क्या करना है? You have heard him. What are your contours to address their points?
Last Supreme Court recent judgment, Your Lordship, where the Supreme Court has said that legal heirs are not liable of a deceased partner. The legal heirs of the partnership firm, they are
Rather, once there is a death of a partner, they are entitled to inherit or become a partner as per
Yes.
the provisions of Partnership Act itself.
Yes.
And they are required to be made partners there. And their liability is only to the extent the partner has rights or liabilities in the
Yes,
from the partnership business. That does not mean that their entire asset will be thrown open for the recovery of any.
yes, that is.
We'll see that. You just give that judgment also. What do you have to say? मोटा मोटी बताइए 5 मिनट में कि आपका, क्योंकि अगला बार सोच के आएंगे, पढ़ के आएंगे क्या क्या सोचना है हमको.
Well, the first issue is with respect to the arbitration clause. The very arbitration clause was there. They filed an application, but they didn't file an application under Section 8 of the Arbitration Act. Section 8 provides there are a number of requirements. When they file a Section 8 application, it has to be accompanied by the certified copy of the partnership deed of the arbitration agreement itself. Unless it is accompanied by that, Section 8 order cannot be passed.
This particular document
My lords.
is a
They had
registered
to obtain,
document.
it is a registered document. They should have obtained the certified copy, file a petition.
You
on the
filed the certified copy, isn't it? You must have filed the certified copy, or you filed the original.
My lords, I filed the, I just have copy, my lords.
Okay, you must have filed the original.
Oh, yeah, my lords. But what is the requirement? Kindly see Section 8, my lords.
No, the point is, there are two kinds of objections that can be taken. One is objection under Section 8 that it has to be referred for arbitration.
My lords.
Other is that there is an arbitration clause and therefore the suit is
Well,
not.
there is a basis, my lords. They had moved an application under Order 18, Rule 17. In this case itself,
For
taking the objection, the same objection that the suit is barred under Section 69. Further, there is an arbitration clause. Ultimately, the matter came before the Honorable High Court, and a revision was filed, my lords. In the meantime, the suit itself was decided, so that became infractions.
Can be
But
called
in-
in another.
okay, please.
But what has happened in that case? There is a specific judgment to the point that instead of filing an application under Order 18, Rule 17, read with partnership, they should have filed an application under Section 8. In that case, they would have succeeded. They were very much right that the matter should have been referred to arbitration. Had they had filed a Section 8 application instead of Order 18, Rule 17. The issue was also considered recently by Karnataka. I could have given. There it was specifically held that they had to specifically file Section 8 application if they have to escape a civil court jurisdiction and go for arbitration.
They cannot simply raise a point.
No,
of
ma'am,
views.
they cannot raise that. Then if they fail to raise it, then the competent civil court will have the jurisdiction. And this fact has
No,
also.
they have raised it in the written statement.
But they have raised it, but they didn't file an application to refer it to arbitration. So the civil court by default got the jurisdiction. If they had filed an
तो
application.
दिखाइए हमको judgment.
It's para 11. Page 12, para 11. If I may place it, para 11.
Yes, read it.
The language of section 18 before and after the amendment is explicit and clear. It requires a formal, independent and specific application before and or at the time of filing of written statement seeking reference to arbitration. The judgment cited by the learned counsel for the respondent number 1 plaintiff rendered by the coordinate bench of this court in the case of P. Tarachand versus Sesmal M. Jain Supra is squarely applicable to the present case on hand. This court in the above said judgment has held that the proceedings pertaining to domestic arbitration, the only provision that purports to oust the jurisdiction of civil court is section 8 of the Act of 1996. The coordinate bench of this court was of view that provision of the Act of 1996 clearly indicates that apart from section 9 there is no provision under the Act of 1996 that ousts the jurisdiction of the civil court. Even section 8 contemplates the matter is referred to arbitration by the civil court only subject to party invoking and complying with the mandatory requirement of section 3 within the time stipulated therein.
आगे पढ़िए.
In the light of the principles laid down by the coordinate bench of this court and also the judgment cited supra, in the present case on hand, the petitioners have not at all invoked section 8 of the Act of 1996. On the contrary, the present petitioners have filed application under Order 7 Rule 11D of CPC seeking rejection of claim on the ground that it is barred by law. Even till today, the present petitioners have not taken recourse to the provision of section 8 of the Act of 1996. The order under challenge does not want any interference at the hand of the court, as rightly pointed out by the learned counsel for the respondent number 1 plaintiff. The right cannot be kept in sleep and be used at will. The petitioners, by issuing the reply notice, has disputed in regard to existence of arbitration agreement so far as present dispute on the hand is concerned. Therefore, it can be inferred that petitioners have waived their right to have the dispute resolved by arbitration. Having taken such a stand in the reply notice, the petitioner now cannot be permitted to contend that arbitral proceedings have already commenced, and therefore suit filed by the respondent number 1 before the trial court is barred under section 11 of the Commercial Court Act. The ground urged and the judgment cited by the petitioner would not displace the reasons and conclusion arrived at by the learned judge. Once may kindly say section 8 at once.
Okay, this is one on arbitration.
Now, my lords,
Further-
with respect to section 69, my lords, the learned trial court dealt to issue in very detail, my lords, and they have cited a number of Supreme Court judgment. And the factual point that has been highlighted is that the money that has been given by these plaintiffs, where it is not a disputed fact that they were ever invested in the business. The learned trial court says that the money was never disputed and this is never invested in the business of the firm. And this fact has not been disputed.
Never invested. That was not your case.
Well, the money was taken for investment in the business, partnership business, my lords. That money and an account was to be opened in the name of partnership firm, and which I was also to be an authorized signatory, my lords. Nothing of that sort ever happened, my lords. The money was kept by the defendant's predecessors, my lord, and the account was also not opened, so it has been given a finding.
Account was not open. Then how the check was encashed?
It was given in the name of Sunil Kumar Yadav, my lords, who has already died, my lords. It was in the name his personal. It was all given in his name. My lords. It was never given in the name of firm. He used as money for himself and never invested it for the purpose of business. And secondly, my lords, there is a receipt, money receipt, that is Exhibit 3 itself, that may be seen, my lords. With respect to the amount that has been given by the performer respondent, the predecessor of defendant number 1 and 2, he has admitted, my lords, that he had received that amount, entire 29 lakhs, and he issued 3 money receipts. That has also not been disputed, my lords. So now it cannot be said that there is no privity of contract between the performer respondent as well as them, because the money that was paid through the performer respondent has also been admitted by the deceased.
Okay, we'll hear it day after tomorrow further. Day after tomorrow हम लोग को कितना केस है जरा चेक करिए तो. सवा दो के लिए देखिए सवा दो के लिए 3 केस फिक्स्ड है, लेकिन इसी को कंटिन्यूटी में सुनना, इसलिए टाइम मत मांगिए, क्योंकि जो पार्टनर रहता है दैट हैज टू बी गिवन प्रेफरेंस इवन बाय द कोर्ट हु हैज डन द पार्टनर. देखिए फर्स्ट अपील नंबर 3 of 2023. The learned counsel for the parties have commenced the hearing of this case. As the court time is over, post this case for further hearing day after tomorrow at 2:15. This matter is treated as part of the अपना appearance दे देंगे, orders के कॉल करेंगे.
Orders which effect Atom 4, first April 159 of 2024.
Nobody appears on behalf of the appellant. You are for the respondent?
Yes.
How do you? Okay, first
We have
appeal.
filed an IA for acceptance of appeal.
That is pending.
No, that is disclosed.
That is disposed of. Counsel for the respondent. All the respondents?
Yes, Your Worship.
Counsel for all the. Are you there for the appellant?
Yes.
इनका वकालतनामा एक्सेप्ट कर लेते हैं.
Court fee is required to be paid.
हाँ, फाइल करिए. ठीक
2 weeks time will be given. The parents are poor person. They have arranged the money. We have to just pay them.
पुअर को पुअरर मत बनाइए DFD करके, ठीक है?
Yes.
अच्छा लिखिए, फिर से लिखिए. Learned counsel for the parties are present. IA number 13333 of 24 has been filed seeking acceptance of wakalatnama on behalf of the respondents.
Yes, sir.
Counsel for the appellant has no objection to complaint. हो गया है ना? आइए हो गया है disposal.
Yes, sir.
फिर से लिखे तो FA number 159 of 2024. Counsel for the appellant prays for and is allowed time till 10th of March 25 to remove the surviving defects preemptively. If the defects are removed within time, post this case under appropriate heading on 17th of March. Authentication fee भी है आपका 10 रुपए के साथ केस डिसमिस मत करा दीजिए.
Order second 5, first appeal
Check कर
47
लीजिए,
of
order.
2015.
वो ऑर्डर शीट चेक कर लीजिए भाई. प्रीएम्प्टी ऑर्डर आपसे ज़्यादा हमको चिंता हो जाता है ये फर्स्ट अपील सेकंड अपील का प्रीएम्प्टी ऑर्डर. हाँ बताइए.
Lordship, may kindly see flag Z, Lordship.
जेड में क्या है?
Lordship, may kindly see the order dated 11/6/2024, Lordship. There was a direction for publication of notice in daily newspaper, Lordship.
हाँ तो
Lordship, I have already published, Lordship, and filed the supplementary affidavit, Lordship. Flag Z, para 2, Lordship, may kindly see.
चाहिए हमारा ऑफिस में. जेड बोल के तो कोई अच्छी नहीं है. सप्लीमेंट्री है.
Supplementary, para 2, Lordship.
हाँ. देखिए फर्स्ट अपील नंबर 47 of 2015. Counsel for the appellant submits that in spite of order dated, in terms of order dated 11/6/24, supplementary affidavit has been filed annexing the extract of the newspaper publication. Peruse the affidavit. Notice upon respond number 1A to 1C, 2A, 11A, 12A, 12B, 14A, 19A, 25A to 25C is accepted as valid. एक आपका IA फाइल हुआ है
हाँ, आइए में
फॉर सब्स्टिट्यूशन.
हाँ, आइए फाइल हुआ है. एक व्यक्ति का नाम छूट गया था, जिसे पारा 7 नाम दिए हैं. Lordship, may kindly see para 7 of my IA petition, Lordship.
कौन सा IA?
IA
There are
number,
two other
Lordship,
IA.
659 of 2024.
659.
Para 7, Lordship.
क्या है इसमें?
Para 7, Lordship. Lordship, it has been mentioned the respondent number 6, namely Prabhasika, died sometime in 2021, but due to inadvertence and bona fide mistake, Lordship, it has been not mentioned in para 1 and prayer portion and other the other paragraph, Lordship. Thereafter, Lordship, file IA number 2072 of 2025, Lordship. Grant leave the claim for reading the respondent number 6 in different paragraph of IA number 659 of 2024 as well as prayer portion, Lordship.
Respondent number 6. देखिए IA number 2072 of 2025. The learned counsel for the appellant has submitted that this interlocutory application has been filed seeking certain amendments in IA number 659 of 2020.
Lordship.
He has submitted that certain necessary amendments in connection with respondent number deceased respondent number 6 has been left out at certain paragraphs
As well as prayer portion.
and prayer of the interlocutory application in IA number 659 of 2024. Considering the aforesaid submissions, IA number 2072 of 25 is allowed. The learned counsel for the appellant is directed to carry out the necessary corrections, necessary insertions in IA number 659 of 2024 during the course of the day in reading.
Lordship.
और बताइए. तो
कर लेते हैं कि अगले सप्ताह रख दी जाए इसको.
ये IA number 2072 of 2025 is disposed of। और ये सारे रेस्पोंडेंट्स का ही डेथ हो गया है ना?
हाँ, बहुत से लोग देखते हैं।
हाँ, उसके बाद लिखिए IA number 659 of 2024। This petition has been filed seeking substitution of legal years of deceased respond number 1, 2, 5, 11, 12,
6 भी हो जाएगा, अब हम 8 कर रहे
okay,
हैं।
1, 2, 5, 6, 11, 12, 14, 19 and 25 after setting aside abatement and also seeking condonation of delay. The details of the legal heirs and successors have been mentioned in various paragraphs of the interlocutory application. Let notice be issued in the IA number 659 of 2024 to the proposed legal heirs and successors of the aforesaid respondents, for which requisites under ordinary process be filed by the appellant within a period of 15 days from now. Post this case on 15th of April, awaiting service. Next.
Item 6, second appeal 260 of 2016.
उसको कर लीजिए फिर छूट
हाँ,
जाएगा।
read कर लेते हैं।
Yes. This is I.
Admitted appeal. The IA is for interim order. Since the final degree proceedings, the execution proceedings.
Interim order of हमारे यहाँ नहीं होता। चलिए आप बहस करिए।
This is admitted appeal. Then it
So,
may be. हाँ तो it may be fixed for a particular.
Where is the
date.
respondent?
Notices we have taken steps for issuance of
Notice is
notice in
complete.
pursuance of the order of admission.
Notice is complete.
Yes. We do not have any notice of that. The notice are not properly served. It has not been listed thereafter. According to instructions, from our part steps has been taken.
Respondent number 3. Okay, in compliance of order, it is a notice upon. As respondent number 3 does not reside at the address, and respondent number 4 received himself. Respondent number 3 is not available. How is respondent number 3 and 4 related?
They are both are sisters, full sisters.
Who is prosecuting the execution case?
The execution case is filed by the said respondents and just they are the decree holders. Lakhan Rai and others. Basically, Lakhan Rai is pursuing that execution matter.
And you are the defendant.
Yes,
So they are your persons.
defendant first party.
Yes.
No, they are
They are pro forma defendants.
they are pro forma defendants.
Yes.
But they are not with me because through them, Lakhan Rai, the other decree holder, he claimed through them. He claimed through this late Mana Ghadwali and this 3, 4.
So they are for all purposes supporting the plaintiff. Did they appear in the suit?
Yes.
Or it was ex parte against them?
No. They appeared. The suit
contested?
Was, yes.
And why do you need a stay?
Because the execution proceedings are there. Therefore, we have filed this.
Merely
It is-
because execution proceedings are there, that doesn't mean anything.
Since it is a partisan suit, so it will be a final degree proceedings. And in the event there is taktabandi and the allocation of the shares are there.
उससे कुछ नहीं होने वाला है। आप इनका नोटिस कंप्लीट करिए। Respondent number 3 को पेपर पब्लिकेशन करिए, IA फाइल करिए for substitute service, whatever. But that is required to be done. देखिए ऐसे number 260 of 2016, counsel for the parties are present. He submits that interlocutory application has been filed seeking stay of execution, which is IA number 3934 of 2024. इसमें लगा हुआ भी नहीं है। समीर जी, इसमें IA नहीं लगा हुआ है। ठीक है? हाँ, IA नहीं लगा हुआ है, आपका ऑफिस ठीक से काम नहीं कर रहा है। From the records of this case, it appears that The notice has been served upon respondent number 4, but so far as respondent number 3 is concerned, the notice has returned by observing that she does not reside at the given address. Counsel for the applicant waits for some time to take appropriate steps. ठीक है, आप कब हम रख देते हैं, मतलब कब रखते हैं बताइए, नेक्स्ट वीक रख देते हैं. You have two options.
After one by
देखिए नेक्स्ट वीक रखते हैं. You have only two options. Either you will tell us that you will take steps at his present and correct address, or you will
take steps for substituted service also.
हाँ जो भी करना है. Post this case on next Wednesday under the heading for orders. Next.
Item 7, first appeal 82 of 2017, along with item 8 to 18.
Particular 12 FAs are there, my lord, analogous, and the IA is there for disposal, my lord. So one IA is already disposed on 20th of February. We were abstaining from that day. And another IA is for the limitation purpose.
So, any objection to condonation of delay?
Not 4 years delay.
I just want to know, you have not filed any counter appeal.
The main petition, memo of appeal भी नहीं था. और objection ने भी recorded और
क्या objection आपका record है?
that as per the CPC maximum period is 90 days Lord Sir, but even they have appealed.
As per the CPC, maximum period is 90 days means?
Means provision of CPC will be carried out under the old act Lord Sir.
Yes.
Till 90 days, but they have it is around
90 days for filing the appeal.
appeal Lord Sir, first. So it is around 1100 days Lord Sir. Extreme delay there is Lord Sir. So we are opposing to be followed out of the.
क्या बोलना है आपको?
Delay is around 4 years, my lord. But
What is the reason?
reason I have stated, my lord, in my limitation petition, that is in paragraph 4, my lord. May I permitted to read out there.
हाँ पढ़िए.
It
कहाँ
is
है?
stated that from the map of Pakatu and
Just
it is apparent that the village Darida, Kadru, Teriatu, Bujur,
अरे
Mira,
रुकिए आइए नहीं आपका रुक जाइए. One person. पढ़िए.
I'm reading from paragraph 4. That is stated that from the map of Pakatu and Shell, it is apparent that the village Darida, Kadru, Teriatu, Bujur, Jamira, Silvarkala and Durgi are adjacent to the village Kori, and the same requires identical treatment. Hence, next paragraph, that when the applicant heard from the other neighboring villages of the village, namely Daridag and Kadru, that the same learned court has granted rupees 3,000 to 6,000 rupees compensation per decimal of the said acquired land, and in spite of that, the same learned court has granted rupees 1,100 to 1,300 per decimal of the land in the present appeal of village Kodi, which is unfair and illegal. It may be noted that land acquiring body, the purpose of the acquisition and the date of acquisition are common in nature for all the above said villages. There, the appellate villages of the village Kodi got acquainted with the fact, then the adjoining villages, namely Darida, Kadru, other above named villages, better compensation has been awarded. The appellants formed a group, anyhow managed to make contact with their lawyers and arranged the copy of the judgment and handed over to the council along with the duly executed Wakafnama to file their cases. So that is the reason when they heard from the other villages that they are getting higher compensation, then they form a group and they contacted their lawyer, and there are several decisions in which even from this honorable court, the honorable Chief Justice recently condoned the delay in land acquisition cases because the land users are very poor and they have also deposited the court fees.
सबका यही कहानी है. सबका same delay है सबका.
Same delay, almost.
Almost से बोलने.
Almost in all the 12 cases, every it's identical. Everything is same.
देखिए आइए नंबर 1475 of 2022 में फर्स्ट अपील नंबर 82 of 2017. State is a contesting party.
Yes, sir. Both DC and railway.
आपको भी बोलना है. आपने भी तो कोई काउंटर तो नहीं फाइल किया.
करना पड़ रहा है फाइल.
बहुत अच्छी बात है. आप लोग ऐसे करते रहिए. 2000 कब का केस चल रहा है ये? 2017 से.
पहले But DFD भी हुआ था process.
आप अपना करते रहिए, आपको जो करना है।
लेकिन इसमें वो
जब कॉम्पनसेशन की बात आएगी तो याद रखिएगा कितना डिले से फाइल हुआ है।
इसलिए वो 2-3-4 पॉइंट इसमें जो है
आप कुछ नहीं, जब का काउंटर ने फाइल किया है तो क्या ही आपको दो चीज
Supreme Court but Supreme Honorable Supreme Court has done is that the filing of the delay, the interest of that period has been waived now. Otherwise, the delay has been conducted up to 10 years. Here the delay is only 4 years.
ये लोग कुछ इनको जजमेंट आप ही देंगे ना, कौन देगा? दीजिए उनको, दीजिए।
कॉपी तक नहीं दिए उनको 3 बार रिक्वेस्ट करके हम
नहीं कॉपी का बात नहीं बोल रहे हैं, ये जो आप बोल रहे हैं कि जिस पीरियड का ये होता है इसमें इस पीरियड का इंटरेस्ट नहीं मिलता है, आप लोग को याद रहेगा तभी। क्या आइए नंबर 1475 of 2022 in first appeal number 82 of 2017 heard the learned counsel appearing on behalf of the parties. This petition has been filed seeking condonation of delay of 1385 days The counsel for the appellant has submitted that the matter arises out of land acquisition proceedings, and the reason for condonation of delay is that the appellants are extremely poor person and they are not able to arrange for money. Further reason which has been given is that arising out of the same date of acquisition with respect to other neighboring villages.
They are
The
for different project also.
No.
project अलग होने से land अलग हो जाएगा।
Different area also. It has been
लिखा ही है,
judgment also.
लिखा ही है different area। ये तो खुद ही लिखा है।
Stated my lord in the
For the
first
different
appeal.
awards were what was prepared.
I'm also in the-
It has
my-
come in. It has been explained in the judgment. Judgment is already explained well that there are 2 villages, and this village is rural areas, and that village was where award was given more. That was populated urban area. That is the reason
Here,
why it was
Ramkar-
distinguished. Everything has been discussed.
Just
by
a
our-
moment. Poor person तो बोले ना ये लोग।
One person is there, my lord, but so far the deed whichever means submitted to the court, my lord, that is not actually relevant, my lord. That's why court has considered this aspect
Just-
and rejected.
The learned counsel for the appellant has also submitted that for similarly situated adjoining villages arising out of the same date of acquisition, different rate of compensation has been fixed, which is higher amount, and the villagers are tribal and are poor persons. He submits that the villagers are entitled for adequate compensation as per the provision of law, and therefore the delay be condoned. No counter affidavit has been filed in the present case. However, the learned counsel for the respondents have opposed the prayer and have submitted that the other cases which the appellant is referring have already been taken care of in the impugned judgment, and they have submitted that adequate compensation has already been given to the appellant as per the provision of law. After hearing the learned counsel for the parties and considering the averments made in the petition for condonation of delay, and also the fact that the matter arises out of land acquisition proceedings, this court is inclined to condone the delay in filing the first appeal. IA number 1475 of 2022 is hereby allowed. ये सारे केस में कर देंगे.
So 24 March में similar cases हैं.
At this, the learned counsel for the appellant has submitted that similar matlab arising out of the same proceeding.
Same award, two villages, my lord. One batch village is also fixed on 24 March.
The learned counsel for the appellant has submitted that similar matters are coming up for consideration on 24th of March. वही बड़ा बैच के साथ
वही बड़ा बैच दे आर एडजेसेंट विलेज मैडम ओनली ऑल
ठीक है।
अदर विलेजेस
उसमें आप लोगों ने भी अपील फाइल किया है क्या? नहीं किया। एच को एडमिट कर ले फॉर्मली, अब तो कोई और डिफेक्ट नहीं है ना। At this learned counsel for the petition, appellant has submitted that let this appeal be admitted. The records we called for from the concerned court, and there are no further defects to be cured. Admit कर दीजिए, call for LCR कर दीजिए, ठीक है? And कॉमन ऑर्डर करेंगे एक ऑर्डर में, क्योंकि ऐसा नहीं कि हर एक केस के लिए जो है ना ढेर सारा एलसीआर, एक ही एलसीआर का कॉपी आ जाए, ठीक है? इसमें सब एक ही है, इम्प्यूग्ड अवार्ड एक ही है।
अवार्ड एक ही
अवार्ड जजमेंट इज कॉमन, अवार्ड आर डिफरेंट ऑन ईच एंड एवरी पर्सन अवार्ड।
ठीक है। पोस्ट दिस केस ऑन 24th of March. किसके साथ टैग करना है? फर्स्ट अपील नंबर,
फर्स्ट अपील नंबर सेम डेट
नंबर बताइए ना।
once in the FA number 176 of 2018.
To be heard with FA number 176 of 2018.
This one is of
यही है
2000. This one is of 2017.
177 है 2018। एक ही चेक करिए तो 24 तारीख को
76, 77, 79.
अच्छा सारे ही ठीक है, उसके साथ टैग कर दीजिए, ठीक है? एक चीज़ आपको बता दे रहे हैं, जिस केस हाँ
176
जिस केस में किसी का डेथ हो गया हो, सब्स्टिट्यूशन पेंडिंग हो या आपका डीएफडी हो गया, वो सारे केस को सेग्रीगेट करके सुनेंगे, टाइम नहीं देंगे इसमें। जिसमें सब्स्टिट्यूशन पेंडिंग होगा उसको सेग्रीगेट कर देंगे, नहीं तो इतना सारा कभी रेडी होगा, कोई ना कोई मरते ही रहेगा। जीवन मरण का चक्र तो चलने वाला है। पता चले इन द मिड्स ऑफ द हियरिंग आपको खबर मिला कोई मर गया, सबमिशन करिएगा, उस केस को सेग्रीगेट कर, ठीक है? तो आप लोग एकदम उस दिन फाइनल डिस्पोजल के लिए क्या चीज़ के लिए?
वो फाइनल डिस्पोजल में हो गया।
चलिए फाइनल डिस्पोजल में इसको भी डालिए, लेट दिस ऑर्डर बी कम्युनिकेटेड।
अब
टैग हो जाएगा
हाँ टैग भी हो जाएगा
उसी के साथ।
और सुनेंगे, देखिए एकदम कंटिन्यूटी में अपने सीनियर को बोलिएगा,
सब कुछ we have prepared and set for this.
सब आप करिए, अपना सब
Citation
तैयार कर लीजिए, साइटेशन सब तैयार कर लीजिए, ठीक है? और अपने सीनियर को बोलिएगा कि हम डे टू डे बेसिस पे सुनते हैं, 10:30 बजे से लेकर 4:30 बजे तक कोई केस नहीं सुनेंगे। और हम फिर एक बार शुरू हो जाएगा तो हम एडजर्नमेंट भी नहीं देंगे,
ठीक है, we are ready for that.
है ना?
वो बैंक डिफरेंट है, वो रामगढ़ का ये यहाँ जारी होगा।
वो तो रामगढ़ वाला है बोल रहे हैं,
वो 176/18 जो है वो अलग बैच है।
अलग बैच है but same मतलब facts are everything
Facts
है
जजमेंट अलग है लॉर्ड साहब।
and identical है, मतलब उस दिन भी वही है, सारा आर्गुमेंट भी वही था। That's right.
टैग मत करिए, टैग मत करिए, उस दिन फाइनल डिस्पोजल
उसी दिन
में
वो भी सुनाएंगे, दोनों सेम चीज है।
टैग नहीं करेंगे, फाइनल डिस्पोजल में डाल दीजिए। और आप कौन सा वाला बैच पहले करेंगे वो भी आप हमको अभी बताइए।
करेंगे सर,
वो देखिए उसमें तो पहले से रिकॉर्ड कॉल फॉर किया हुआ है, उसका रिकॉर्ड आ जाने का चांस ज्यादा है।
नहीं आ गया है,
आ गया है उसका रिकॉर्ड, तो अब इसका हो सकता है नहीं भी आए, अगर आ जाता है तो हम लोग
they are sending the photocopy तो बोलते हैं हम लोग we send it through fax ये मेल तो आ जाता बोलते हैं।
आप लोग भी तैयार हो जाएंगे, स्टेट यूनियन ऑफ इंडिया, ठीक है? पूरे जिम्मेवारी के साथ किस केस में चार्ट बना लेंगे, कितना जमीन इन्वॉल्व है, कितना कॉम्पनसेशन मिला है, इनका कितना क्लेम है, ठीक है? ये सब का चार्ट नहीं रहेगा तो ये बैच मैटर्स नहीं डिसाइड हो सकेंगे। कॉपी ऑफ क्या चाहिए आपको बताइए? मेमो ऑफ अपील मिला है, मेमो ऑफ अपील मिला है,
2 लोगों का मिला है मुझे, बाकी किसी का नहीं मिला।
We have filed at the time of filing the appeal. We have filed.
आपको मेमो ऑफ अपील चाहिए?
ये चाहिए, उसके बाद जो भी अभी जो सब्स्टिट्यूशन फाइल किया, लिमिटेशन फाइल किया, कुछ हमने सर्व तक नहीं किया।
ऐसा नहीं होता है, बिना सब किए कैसे हम फाइल कर सकते हैं? We have filed each and every document, madam, and copy is also been sent.
आज कितना केस है?
Today 12 cases this time and 2 other cases also CMP for restoration.
आपका तो पीसी में कुछ ना कुछ तो होगा ना आपके पास?
2 तो फाइल है मेरे पास, 2
फाइल है।
उसमें भी इनकम्प्लीट है।
Identical, my lord. There is no change.
नहीं आप एक फ्रेश सर्विस कर दीजिए, पूरा फोटोकॉपी करा के उसको सर्व कर दीजिए। सारा रिकॉर्ड, कोई भी आई है जो डिस्पोजल हुआ है, जो पेंडिंग है, सारा का सारा रिकॉर्ड आप उनको प्रोवाइड करिए। जजमेंट तो कॉमन है, जजमेंट एक सेंटेंस, मेमो ऑफ अपील भी अगर कॉमन है,
कॉमन है, खाली पार्टीज नेम है डिफरेंट, बाकी
हाँ, लेकिन आप दे दीजिए प्लीज प्रोवाइड इट। ये सब राउंड में ना टाइम अगर होगा तो अच्छी बात नहीं है, फिर हम रिकॉर्ड चेक करने लग जाएंगे, क्योंकि हो सकता है सिर्फ स्टेट को सर्व किए हो, यूनियन ऑफ इंडिया को नहीं सर्व किए हो, पॉसिबिलिटी है ना इसकी।
And when at the time of corona period we have served the copy through, at that time we have given the liberty to through mail.
अभी कोरोना खत्म हो चुका है,
मेल के थ्रू हम लोग भेज चुके थे कॉपी टू द।
हम लोग जो है, हम लोग और वो लोग भी पुराने जनरेशन को बिलोंग करते हैं, इसीलिए खाली सॉफ्ट कॉपी से नहीं चलेगा। ठीक है, हो गया सब, वही आइए ऑर्डर्स खत्म।
ये बैच हो गया।
हाँ बताइए, और क्या केस है आपका? क्या है? 37 में क्या है? सब ऑर्डर्स खत्म करेंगे अभी।
27 को वो अगर हो जाता है सीरियल नंबर 37, वो ऑर्डर 41 फुल 11 का
ऐसे नहीं होता।
एग्जीक्यूटिव कोर्ट इस प्रोसीडिंग नोट 3 तारीख को डेट दिया और उसमें आगे पर
सुबह 10:30 बजे क्या कर रहे थे?
आई वाज इन होप दैट
ऐसा होप मत रखा करिए, यहाँ पे कभी कभी एक केस भी नहीं होता है।
मे बी टेकन अप
नहीं ऑर्डर्स।
Item 19, second appeal 609 of 2017.
फर्स्ट अपील एक बार शुरू हो जाने के बाद कभी कभी पूरा दिन भी चलता है, मालूम नहीं है आपको ये बात? ऐसा नहीं हो सकता, जब ये क्या है, ये ऑर्डर्स में क्यों है?
Notices issued upon respondent number 8, 9, 10 to 12, 14, 16, 18, 19, 21, 2,
हाँ क्या हुआ, आधा लोग मर गया,
हाँ 3 को मारा हुआ है हम लोग।
तो क्या करें हम?
ये रेस्पोंडेंट नंबर 10 डाइड है, रेस्पोंडेंट नंबर 19 डाइड है, लेकिन 19 का नोटिस सर्व हो गया, वैलिडली सर्व है। रेस्पोंडेंट नंबर 27 डाइड,
19 का वैलिडली सर्व मर गए फिर भी।
हाँ रेस्पोंडेंट 16 to 19 साइंड,
मरने के बाद कहाँ सर्व करते?
लॉर्ड एज पर ऑफिस नोट रेस्पोंडेंट।
अरे ऑफिस नोट की बात छोड़िए, जो मर गया उसको कहाँ सर्व कर दिया? ऑफिस नोट, वकील साहब ऑफिस नोट से चलेंगे क्या? बताइए।
Respondent number 11, 12.
Essay number 609 of 2017. As per the office note, respondent number 10, 19 and 27 have been reported dead. (27) भी तो डेड है।
हाँ 27 टाइम
27 भी इंक्लूड करिए। Counsel for the appellant pays for time to take appropriate steps in connection with service of notice. आप चेक कर लीजिएगा किसको क्या करना है, ठीक है?
Respondent 10
So 10 तो लिख ही दिए। Appropriate order will be passed on the next date with regard to service of with regard to acceptance of service report in connection with one or the other respondent. जिसका इसका एक्सेप्ट करना है अगला डेट में कर देंगे, आप अपना डेट का जरा चेक कर लीजिएगा, ठीक है? डेट दे दीजिए इसमें, कोई भी 15-20 दिन बाद का, होली के जैसे बात कर दीजिए।
Item 20, second appeal 338 of 2018.
Sir, IA has been filed to substitute as a legal representative of respondent 60. Details are at para 4.
When did he die?
29/10/2024.
अबेटमेंट वगैरह के लिए फाइल किए हैं?
It is within period.
Within period. 24.
24. 29/10/24 and IA has been filed on
IA number 668 of 2025. In second appeal number 338 of 2018, this petition has been filed seeking substitution of respondent number 6, who is said to have 16, who is said to have expired on 29/10/2024. The details of legal heirs and successors have been provided in paragraph 4 thereof. Issue notice to the proposed legal heirs and successors of respondent number 16 in the interlocutory application for which requisite under ordinary process be filed within a period of 1 week from today. Pose this case on 18th of March. 18 मार्च को नहीं हो पाएगा. On 2nd of April. Next.
Item 21, second appeal 500 of 2018.
Three IAs, Your Lordships. The first IA is 1281. This IA was filed, there was some incomplete particulars mentioned. There were 3 heirs, only 2 heirs would be mentioned. So accordingly, Ladyship, we have filed another IA with regard to substitution of the same deceased appellant number 2. So this IA I am not pressing, Your Lordship.
IA number 1281 of 2025 in essay number 500 of 2018, the learned counsel for the appellant submitted that the petition was filed for substitution of deceased appellant number 2, but there has been some error in giving the details of the legal heirs, and therefore another interlocutory application has been filed, being IA number 1332 of 2025. Under such circumstances, he submits that he does not want to press IA number 1281 of 2020. Considering the submissions, IA number 1281 of 2025 is dismissed as not pressed, and IA number 1332 of 2025 will be considered.
Yes.
अब बताइए वन इसमें क्या है?
Ladyship, the appellant number 2 had died.
तो आप बोले amend the prayer of the
No, this is 1332 and 1338. There are 2 IAs. 1332 is for substitution.
1332 order 41 rule 3 pray to amend the memorandum
Yes.
of
I'm sorry.
1338 your substitution.
1338.
1338 लिखिए है ना. He will press 1338. पहले 1338 कर देते. अपीलान नंबर 2. ओके. कौन है इनके लीगल
Appellant
heirs?
number 2 is Purushottam Das.
Okay.
He died on 15/5/2021 and is survived by the heirs which have been disclosed to leadership at paragraph 4. And the delay was occasioned that has been given explanation from para 6 onwards.
So you are seeking setting aside abatement.
Setting aside
Delay.
abatement, condonation of delay, there is
Any counter affidavit filed to this?
leadership, this is yet to be admitted. So notices has to go. Because,
देखिए IA number 1338 of 2025 in essay number 500 of 2018. Counsel for the appellant has submitted that appellant number 2 has expired on
15/5/2021.
15/5/2021, and and the proposed legal heirs and successors to be substituted have been mentioned in paragraph 4. He has submitted that the notice may be issued to the respondents on the point of substitution of the appellant number 2. Considering the submissions, let notice be issued in IA number 1338 of 2025 to the respondents for which requisites under ordinary process be filed within the period of 1 week from today. Respondents को notice कर दी जाएगी. हो गया? और क्या है?
Because there is one IA for amendment of the memo of appeal, because the council earlier had filed only just a brief memo of substantial question of law. So that was not incorporated in the memo of appeal. Perhaps your ladyship would not have entertained the appeal otherwise. So by way of abundant caution, we have filed an IA for praying for actually amending the memo of appeal.
To what extent? To bring on record the substantial questions?
Substantial questions of law.
Where
Because
is it? 1281.
Para 7, the substantial questions of law have been narrated.
Okay, लिखिए. IA number 1332 of 2025. Counsel for the appellant has submitted that this interlocutory application has been filed seeking amendment of the memo of appeal to bring on record the proposed substantial questions of law which are involved in this second appeal. He submits, considering the aforesaid submissions, the IA number 1332 of 2025 is allowed and is directed to be treated as a part of the main memo. Okay? आपका सब्स्टिट्यूशन का भी आइए है आपको
दो
कुछ
फाइल
करना
में।
है
दो आइए
आइटम 15 में और आइटम
FA 97 and FA 100.
कौन मरा है
In first appellant, appellant number 5, Tumam Begia has died, living died, 2 sons, my lord.
अभी तो वो लोग चले गए अब अगला डेट में सोचेंगे क्या
So I'll mention so that it may be taken up in the next prior to the 24th.
फाइनल डिस्पोज 24 दिन को है।
ये दोनों केस को जो है ना इसको एडमिट मत करिए दोनों केस को ठीक है इसको जो है नेक्स्ट वीक ठीक है उस दिन याद रखिएगा ऐसा मत करिए प्लीज डोंट डू दिस एक भी केस में सब्स्टिट्यूशन छूट जाएगा ना तो पूरा जजमेंट खराब हो जाता है द मैटर विल बी रिमाइंडेड बैक इमीडिएटली यू डोंट अंडरस्टैंड दिस
That is my fault. So
चलिए डिले तो कंडोन हो गया दोनों में अपीलांट का डेथ हुआ है ना
appellant के death and I have to file after
वो दोनों को ना सेग्रीगेट कर दिया
yes वकालत नामा order
नेक्स्ट वीक।
और 10 मिनट बस हो गया अभी और है कितना केस है ऑर्डर
इनका तो सीएमपी भी है।
किनका
मेरा भी 2 cases है CMP
ऑर्डर्स में डिफेक्टिव
defective I have directed to file wakalat nama of the substituted appellants. I have filed in both the cases.
कितना है लगभग 10 होगा
It's 28,
नेक्स्ट वीक नहीं नेक्स्ट
28 and 29. I filed the
जिस दिन ऑर्डर्स कम होना उस दिन डन बाकी रिमेनिंग 5 बज गया आप फोन